but not yet broadcasting the webinar. And we are broadcasting the webinar in 5 seconds.
Good afternoon, good evening, and good morning. And thank you very much for joining us for today's DREx webinar on the future of cross-border resolution. My name is Timothy Foden, and I'm a partner with Lalive in London. And today we have the great honor of welcoming a number of distinguished panelists to join us and share their views on that very subject. We'll be joined shortly by Lord Mance, former Deputy President of the Supreme Court, as well as former Judge of the Supreme Court of India, Justice A.K. Sikri, and the former Chief Justice of Western Australia, Wayne Martin AC QC. I'll be joined in moderating this panel by Jiva Filipic, who is counsel to the ICC Court. Just to give some brief introductions to our distinguished panelists, I'll start with Lord Mance, who I see has just joined us. Welcome, Lord Mance. Lord Mance was Deputy President of the Supreme Court. He sat from 1993 to 1999 as a commercial judge and was appointed to the Court of Appeal in 1999 and to the House of Lords in 2005, where he spent 4 years as a law lord before becoming a justice of the Supreme Court upon its formation in 2009, and then served as its deputy president from 2017 to 2018. Lord Mance joined 7KBW in 2018 and now sits as an arbitrator in ICC, LCIA, UNCITRAL, and ICSID disputes involving a range of industry sectors. Justice A.K. Sikri was appointed as a judge of the Delhi High Court in 1999, and he was appointed as acting Chief Justice of the Delhi High Court on the 10th of October 2011 and elevated as a Chief Justice of Punjab and Haryana High Courts in 2012. In 2013, he joined the Supreme Court of India and retired from the bench last year in 2019. He now sits as a judge of the Singapore International Commercial Court, and I should mention that Lord Mance also currently sits as an appellate judge on that court. The Honorable Wayne Martin AC QC, who I had the pleasure of meeting last year in Perth, was Chief Justice of Western Australia from 2006 to his retirement in July 2018. Prior to his appointment, he practiced at the Western Australian Bar in the field of commercial litigation, mainly involving disputes in the mining, energy, resources, construction, and financial sectors. His practice included international and domestic arbitration. As Chief Justice, he created and managed the arbitration list of the Supreme Court of Western Australia, and he's widely lauded for his technological innovations that further increase the efficiency of the Western Australian judicial system. He now sits as an arbitrator via 39 Essex chambers. Their initial interlocutor today will be, as I said, Jiva Filipic, who's managing counsel of the ICC Court in Paris, France. And then today we'll have some concluding remarks from our friend Abhinav Bhusan, who is with the ICC in Singapore. So with that, I'll turn it over to Jiva, who will start with questions.
Hello, thank you, team, and hello, everybody. Thank you for joining us on a Sunday. We now have a very reliable means of confirming who's really interested in arbitration. So today we are going to speak about take stock about what happened during the recent few months, and try to discuss with very eminent speakers and with speakers who can definitely give us a very useful insight into the questions of how will all this reflect and how will all this shape international dispute resolution in the future. I must probably start with a disclaimer. You will probably notice that for some obscure reason, the discussion today may be slightly skewed towards arbitration as opposed to other international dispute resolution. But it's true that we have a panel of eminent ex-justices here, so I'm sure that they will turn it around when necessary. And you're also more than welcome to ask questions on any area of international dispute resolution. Now, without further ado, I would start by maybe inviting Justice Sikri to comment first on whether you think that this crisis will have long-lasting effects on how we organize and conduct international disputes, and in particular arbitration in the future, or do you think that this will just have been a long parenthesis after which we'll all go back to life as we knew it before, including a lot of traveling, long hearings, in-person deliberations, and all the beautiful things that we have been seeing until about January or February 2020.
Thank you, Jiva. I think let me answer your question, which is very pertinent question, and the entire world is discussing about COVID in a different ways, depending upon which field a person belongs to. Your question is that whether it is going to have lasting effect on the way the arbitrations are conducted, or it is, as you have yourself used the other expression, long period. And so that would depend upon how much we know about COVID-19. As of today, I think we hardly know much in spite of the fact that this hit China almost 4 months ago and entire rest of the world more than 2 months ago. But still we are struggling with so many issues, whether we don't have any vaccine even till date. And therefore, but it is a contagious disease. It has impacted, I would say, lives, because lives are taken away, livelihood, many have been rendered unemployed, and lifestyle, the way we are maintaining and even today with social distancing. Now, therefore, we are not sure today whether there would be an end to this and that whether the curve would flatten in 1 month time, 2 months time, or 6 months time, or some people are saying it may be 2 or 3 months. Some people are saying 1 year or 2 years. We don't know anything. So therefore, everything would depend upon. In that context, coming to the arbitration. So look, what I would say is that yes, things have to go on. We have to move on. And the arbitration board also wants to move on with this kind of lifestyle which has changed because of this. Not that things are not moving and disputes would be there, and because of COVID itself may become a reason for more and more disputes in commercial worlds because of so many reasons, not necessary to discuss here. So therefore, we have today adopted this technology that at least technology has come to the rescue of the arbitration world, that today we are able to do the arbitration work, international arbitration work, through the medium of video conferencing, so in a virtual hearing. Now, question is whether how long it would remain and how much it remains. I hope that in spite of all these things, what I feel is that I have a hope in humankind. We have faith, we will bounce back, and we will be like this, which we were in pre-COVID situation, maybe after 6 months, after 1 year or whatever, the life would get normal. But during this period, what COVID is going to teach us and what the lesson we are going to learn from this. Number one, that yes, in the arbitration world, we use this technology in a long way, in a big way. We have made use of it. In the process, we have learned the advantages and disadvantages of this technology also when the hearings are going to take place on video conferencing. All those may be discussed today also in due course of time. But what I feel is at the end of the day, and when, as I said, that I am hopeful that normalcy would return, but then this technology or this period would teach us that we have to go along in future with a hybrid system, that wherever it is necessary, we and the taking benefits of the advantages of this technology, wherever it becomes necessary, we make use of it and for our benefits, and wherever it is necessary that physical hearing should take place, we should do that also. This is what my take is.
That's I was not surprised by your answer, and I hope you're right. I hope that we will take what we learn and use it to the extent appropriate also in the future. And I hope that doesn't go only for, you know, the use of technology, but also for a more enhanced use of all the case management tools that we have been stressing more, I think, during this period, but have always been there. I mean, I'm looking at when we were preparing at the Secretariat at the ICC court, when we were preparing this guidance note on mitigating the effects, which is true, is aimed in the first place to, you know, help parties and tribunals avoid to a certain to mitigate and even avoid to the extent possible the effects of the COVID crisis. But if you really look at it, all the case management tools, nothing is really new. It's just that now there is really, it's critical that they be really employed. And I hope that I don't know what also what you, Justice Sikri, think and the others think about whether this, you know, like the emphasis of, you know, focusing on, you know, midstream conferences to streamline the issue, to decide issues on paper, certain issues on paper, to decide certain issues with the expert and so on, all these alternative ways of organizing the proceedings. Do you think this will stay, or do you think this will fade as soon as we are able to forgo it?
I think it would stay, because as you have rightly mentioned, I didn't go into those details. What are the advantages of this technology? In what way? I tell you, I have written one article about few weeks ago in respect of our Indian judicial system. As everybody knows, that we are under so much pressure as far as arrears are concerned. So we need to have proper court management, case management to grapple with those areas. So I have said that, look, no doubt technology is being introduced in Indian legal system for last or judicial system for last few years, but it had not taken that kind of strides which it was required. But this COVID and technology, because today the courts are functioning only because with the aid of this. And I have said that it is going to benefit us insofar as our case management and court management is concerned, and which will help in reducing the arrears also. Same thing I think applies even to the arbitration word. There are many advantages, as you rightly mentioned, about case management, etc. And even see it from another angle, even before this pre-COVID-19 situation, insofar as international arbitrations are concerned, accept evidence under certain circumstances, because evidence also in certain circumstances used to be on video conferencing, and final hearings, because most of the things are online. Of course, filing of the documents, etc., where some changes have been made now in what form they should be filed. But then most of the proceedings are held online, where by emails, etc., we keep discussing. And many times, say for procedural hearings, etc., where some protocols are to be determined, what happens? The arbitral tribunal consisting of 3 arbitrators would be in different jurisdictions. The parties may be in other jurisdictions. For this, such small hearings, even up till COVID-19, such things had been happening on video conferencing or even teleconferencing. So we have been making use of the technology. And that is why I said that when for 2 months, 3 months, or 4 months, 5 months, we don't know how much, we use this technology. Of course, we have to learn more skills. We have to upskill our existing skills also in the process, which would be required. But then at least in those circumstances and in those contingencies where we find that video conferencing can, it should take place instead of physical hearing, and it will not affect the advantages of physical hearing, then in those cases, the cost saving and other, you don't have to travel, don't have to waste time, and all these may lead to this process may continue, at least in selected cases, forever. This is what I feel.
Lord Mance, what is your take on what exactly should be considered when deciding whether or not to postpone a hearing, sometimes for a long time, especially if everybody concerned is busy, postpone the hearing, or maybe instead of initially planned in-person hearing, hold a hearing by video, or consider also other alternatives to discussing issues, certain issues, by other means rather than by holding a hearing. It's a long question. I'm sorry for that.
Well, can I start by saying that it's a great pleasure to take part, and I wholly agree with what Justice Sikri has just said. This seems to me a huge opportunity. We used to try, when I sat in the Judicial Committee of the Privy Council, hearing cases from foreign jurisdictions, to persuade the parties that they should use our video facility, which sometimes they did, but very often you got the impression that